Good morning. Welcome to the First District Court of Appeals. We have two cases on our docket scheduled to be argued this morning. When I call the case, if counsel would please stand, state your name, the party you represent, and your readiness to proceed this morning. The first case is C-24-0646, Brown versus Board of Education.
Your Honor, John Ford for the plaintiff. Your Honor, Ryan Flynn for Reading.
Okay, great, thank you.
Your Honor, Ryan Flynn for Reading City School. I'm here with my partner, William Diaz. He should be joining us just a moment. I spoke to him. He's in the bill.
All right, thank you.
Thank you.
My name is Skilled Anderson. I'm here on behalf of defendant appellate Shook Touchstone 58.
Thank you.
I'm Bill Kelly, Your Honor, and I'm here on behalf of Charles at Jordan's Construction Builder.
I'm Bruce Moore, Your Honor, and I'm here on behalf of Voorhees, Sloan, Walsh, Rosslyn, Architects Incorporated, and ready to proceed.
All right, and my understanding is that we will be dividing argument this way. Mr. Dieters, 6 minutes, Mr. Kelly, 3 minutes, Mr. Anderson, 3 minutes, and Mr. Moore, 3 minutes. Is that your understanding as well? And do you all want to come forward, two of you maybe, or do you want to stay there? How would you like to arrange yourselves? All right, and the rest of you feel free to come forward as you wish when it's your turn to speak, and we'll manage that as needed, okay? And when Mr. Dieters arrives, we'll be glad to welcome him to the argument. All right. Mr. Forg, if you would like to come forward. Oh, and I apologize. We do have a second case. Let me call that one. C-25-0001, Tabasha versus Abdul Rahim. Is counsel present on this case?
Yes, Your Honor. Yes, Your Honor.
And could you tell me your names and the party you represent?
Nadeem Qureshi for appellant.
All right.
I'm Blake Summers for the appellate, so I'm not used to that. But me, I have to review.
Great. Thank you very much. All right. On the Brown versus Board of Education case, Mr. Forg, would you like to come forward?
Your Honor, John Ford for the appellant plaintiffs. I would ask for 5 minutes of rebuttal.
All right. And you may start when you're ready.
Okay. Your Honor, may it please the court, may it please opposing counsel. This is a case that involves some flooding caused by the 4 defendants who are working on the reconstruction of the main school in the Reading School District. This began in 2017, the reconstruction began. My clients own a residence. Now this, the school district and the construction is located at the top of, well, it would be Ridge Avenue coming north Columbia, they're in a street, Bosner, which is down below, so it's right below where the construction occurred. And when the first thing when the construction began was they sort of tore out all the groundwork around there, so when it began to rain, there was flooding that came down. Now and the flooding eventually got so severe that it entered my client's property, destroying their basement and the landscaping around there. Now this began, the first flooding, but not that serious, began in June of 2017. The next thing that happened was the Ohio EPA came in and ordered them to perform some work. There was an attempt to...
Mr. Ford, can you share a little bit about your argument as to cause? So what do you believe caused the flooding in the Browns' house?
The flooding was caused by the failure of the contractors to properly prevent the flooding. If you look at the pictures that we've put in there, or you could look at there's probably hundreds of pictures in the record that have put in. It shows, you'll see they tried to put up a plastic fence. The plastic fence actually concentrated the water, so it flew down directly into my client's property. You can see big floods of water come in there, and that's what...
Why did that happen?
I think they were
negligent.
negligent.
Was it about the water and the shape of the land that caused it?
It was negligent, and a negligent attempt on the part of them to repair. If you'll notice...
Do you have a position on whether the negligence was on the part of the construction companies or of the architect?
I believe it was everybody, Your Honor.
Counsel, don't we need an expert to help guide us on that?
Let me stop for a second. We did not have an expert there, and I'll tell you why, because as I've indicated in there, you do not need an expert to understand what's happening. I think a relevant document for all of the three of the questions that you've all asked would be, if you look at the affidavit of Andra Brown at Exhibit 4, which shows something they called a site observation, which occurred in March 5th of 2018, so it was within the statute of limitations. And there is an expert. It was the expert hired by the defendants. His name was Ron Roberts. He was a civil engineer, and he was the one who was doing the civil work along the side. And he specifically said and admitted that up until that time, the flooding was continuing and they were still having problems. And what he was going to do, he was going to try a new method at that time, which was putting bales of hay up, which had never occurred up until that time, and that was the way they were going to attempt to do the stopping. But the flooding had continued since the first one began in June of 2017, but the more serious ones began on October. I think the first date
Well,
is October.
flooding can happen. I mean, that's a natural phenomenon, right? Like water can come from the sky and there can be too much of it.
No.
And so
No.
So
No, I mean,
flooding
what
is
you're-
not a natural phenomenon.
Yeah, what you're saying is the rain is natural, but the way the channel and the way the water would flow, now that was changed by them. The swale that was along the bottom of the property that diverted the water into a creek that flew a couple houses down from my clients was cut down in June, prior to June of 2017. So when the water came, there was nothing to prevent it from flowing into the natural course of when it was, and it went straight down. And then that was exacerbated by the fact that these plastic fences were put up that directed the flooding into a channel that led directly to my client's property and into their backyard. And it caused the basement door to open and ruined.
Well, I mean, I've looked at the photographs. I understand what you're talking about,
Yes.
and maybe I could be misunderstanding something, but wasn't the idea of the plastic fences to stop the flow of water? I mean, they're put sort of across the hill, right?
Yes. Well, first of all, I think that the cutting down of the swale at the beginning, that was a mistake from the very beginning, and that was not supposed to occur. But I think the attempts when the EPA came, Ohio EPA came and started directing them was to try and stop the water, but it just didn't work. If you see the pictures we have in there, or the pictures that are in evidence that show the plastic fencing that was put up, you'll see that what it actually does is it'll come down, and that'll cause it, instead of flowing in a spread out manner down the hill, it will concentrate it in one area where it goes through the plastic fencing and creates it's like creating a much deeper and thicker flow of water down there, which would flow directly down against my client's property and build up in the backyard and force open the basement door on the back of the building.
What's the basis, counsel, for establishing a violation of the standard of care with respect to these kind of construction projects? Because it seems like what you're describing is a very technical area, and I certainly don't appreciate the ins and outs of it. Back to my question about expert. Is this within the ken of a layperson to understand the complexities of this flow of water down this hill and what should be done about it?
Yes, it is exactly, and I'll give you their expert, Robert Robbins, when he had conducted this site observation in March of 2025, he printed out a sheet. You'll see it's the last page in Exhibit 4, where he describes what's happening, and that's exactly what he sets forward, and he states, and he simply explains that all they're going to do is put bales of hay up there, and you're going to have to wait till the land dries to put it up there. And that's something that he was representing to the people because they would readily understand it, and they would understand what steps that the expert witness or the contractors were going to take to do that. And that's not anything that requires an expert testimony. The case that I cited, I think it's Ramage or something.
So was that within or without, like within the standard of care or outside of the standard of care to put up the bales of hay?
I don't know how it worked, Your Honor. Prior to that, the standard of care, they had done nothing, just putting up the simple plastic fences, as you can see, actually channels the water and comes through.
And are the fences inside or outside of the standard of care?
That's outside the standard of care because it did not prevent the flooding that would have occurred.
So
Is that the basis, whether it worked or not, to determine whether it's within or without the standard of care?
I'm sorry, Ms.
Is the determination of whether or not the solution worked or not, is that the sole criterion to determine whether or not there's been a violation of the standard of care?
Well, Your Honor, what would happen is whether there was damage that occurred and whether it was caused, or if they could have taken any steps to prevent it. And there were no steps taken to prevent it that worked, and they made no attempt to do it. There were 3 times that the flooding was stopped by the Ohio EPA because it was insufficient, and it continued along long past the time when the first flooding occurred. It occurred for more year, and you can see in the documents that the city is attempting to try and all of the contractors and the school district are trying to put together a way to prevent that flooding from continuing, and it doesn't work whatsoever. They did not take any effort, and in fact, when they were told by when my clients approached the contractors, they were told, we're doing what we can. That's it, if the flooding occurs. Now, it's interesting, the steps they took that would have been very easy. There were 2 things they did. First of all, they tried to restore the swale along the bottom, and the second thing they tried to do was channel the flow of water back into the a couple of houses down where the slope went down and there was a retention creek, a natural creek. They did not do that for over a year or make any attempt in that part. And we would argue that that is a continuing violation. Certainly, it's an issue of fact that would create an issue of when the trespass stopped and when it was completed and when the statute of limitations would begin to run, because it would not begin to run until the proper steps were taken.
Did you
to
preserve
prevent
that argument below? Is that something that you briefed at the summary judgment stage below?
I'm sorry, ma'am.
Did you brief that argument below in your
Well,
summary judgment?
What we argued in the case below. Now, first of all, let me say, the motion for summary judgment was brought by the defendants on the affirmative defense that there was a violation. So it's their burden to prove that any water that was flowed was completed. You'll see that that's in that Sexton versus City of, from the Ohio Supreme Court came out of the Sexton versus the City of Mason, which is an exception to the Harris versus Liston case. It talks about when the statute of limitations starts, there's a discovery rule, and when it would end. And what the burden of proof, when you're trying to make that affirmative defense, it falls on the defense to make that forward. Now, they offered no evidence whatsoever of when the flooding was completed. They argued only that it began.
Did you respond, though, with the continuous trespass doctrine in your summary judgment response?
What we argued in the summary judgment was that the damage, the discovery, actually didn't start until October 7th, because that was when the first flooding that damaged my client's property occurred.
So you had a different theory with regard to how the statute of limitations applied
Well, we argued that
for
it
the
didn't.
trial court?
It didn't start until October 7th, yes. Well, but it still doesn't mean, it's still the burden of the defendants to show that it's a completed statute of limitation, and that would be the case of the Sexton case that I cited before. And I would also say I cited a case called Bull versus Griffith. It's not an appellate court case, but, it's not a Supreme Court case, but it's an appellate court case out of the 4th District that I would say is exactly on point, because the continuing violation occurs and they order the statute of limitations does not apply until the trespass is complete or the flooding would be complete in this case.
All right. If you would like to reserve 5 minutes, you're out of time.
Okay, thank you very much.
Thank you. All right, Mr. Dieters.
May it please the court, Your Honors. I apologize for being late. I was literally pulled out of my driveway and hit a traffic jam within 2 minutes after I pulled out.
That's
So
all right.
I apologize. I'm here on behalf of the Reading Community City School District Board of Education, and we actually have 3 attorneys that want to speak today. So if I could take 6 minutes, Your Honor,
Yes.
that would be great. Okay.
Yes.
And because of my limited time, I'm just going to kind of try to address a couple of the issues. Essentially, the facts, I think you have them. They've been briefed well in our case, but there are a few items that I want to address here. One is that there is the discovery aspect that the Supreme Court put into place in the Harris case, which is similar to the discovery like they do in medical malpractice cases where there's potentially a negligence action. The plaintiff may not discover that action happened sometime later. Then once the discovery of that happens, then that 4-year statute of limitations exists. I think the Harris case is very interesting here because if you look at the facts of that case, it's kind of similar in that there was that standing water that the original owner of the house knew about, and then therefore when the second owner took over the house, they couldn't argue that they had just discovered it.
Well, it seems to me that the plaintiff's argument, perhaps, on the statute of limitations issue is that there were maybe different construction issues occurring, one with the removal of the trees, which might have led to the June 2017 flooding, but then another with the addition of these fences, which I think they're claiming failed to prohibit the flooding after the October storm. Do you see those as
Your Honor,
one problem or 2 problems?
I think it's one problem, and potentially it could be 2 if you had an expert to go to Judge Moore's position, is that we don't know what the causation is because there's no expert. And I would tell you, just listening to the appellant's statement here, I was kind of thinking they were bolstering our argument, the fact that you need an expert because there was disagreements on the different types of mitigation that may have been used and not used. And I think you've also kind of pointed out, even if you had the best mitigation possible, you could have a significant 100-year rain event that would still potentially flood and there would be no negligence. So it's hard to tell what caused that to happen. And in the event that happened in June 2017, it was significant enough that the plaintiff took photos, numerous photos, I think 30 complete, and actually met with the school district representatives to say, look, I got a problem here, this is flooding. So to our position would be, in which the trial court agreed with, that was a cognizable event at that moment in time where they believed that there was a problem with something happening in the construction behind their home. And if they were going to file an action at that point, they would have to have done it in 4 years after that event.
What is your position on the argument that your opposing counsel made that the defendant, I'm not sure which defendant, but the defendant's expert served to show what the cause was?
I think it's that I have to go back and look at the transcript completely, Your Honor, because I wasn't expecting that to be an argument here. But I think that there was potential different causes that the expert from the defendant's aspect spoke about. And whether or not they knew exactly what that was at that point, I don't know. And that expert also did not say that the standard of care was breached, just that there's potentially other reasons why it could have happened, right? Or there might be, and again, remember, it's only a reasonable standard of care. It's not, you could meet your standard of care, and then you could still make it better, even though you may not be negligent in the process. So I think that's kind of an argument that doesn't have a lot of weight in our position. And I think that he also has the duty to bring that expert. He has to prove that standard of care was breached.
So, counsel, isn't this something that doesn't happen absent negligence? I mean, you don't have these kind of construction projects that cause flooding. That's not expected, is it?
Well, Your Honor, I think any time you're gonna disrupt land to do a construction project, especially to the extent of a project as large as building a K through 12 school, that there is obligations upon the contractors to mitigate potential water runoff, and because once you start disrupting that land, you don't have all of your sewers in yet and all those kind of things. So just like when you drive by the highway and you see bales or fence or plastic fences, so there's an obligation to mitigate at least temporarily while you're doing that. But as an owner of the property, we relied upon our architects and our engineers to provide us that standard.
Do we know, I mean, I don't think there's any dispute here that water infiltrated the Browns' house. I don't think any party is saying this didn't happen. It happened. But do we know why? I mean, is it that there was some mitigation effort that should have happened and didn't happen? Is it that the mitigation efforts were done negligently, or is it that every standard of care was followed and this was just some sort of, terrible rain event that really no one could have prevented? Do we know which scenario it is based on this record?
Your Honor, I don't know if the record right now could answer that question affirmatively, because we are here on summary judgment action because of the statute of limitations and because of failing to identify the expert, which that could have been sort of developed more at that point had they had an expert provide testimony, but they didn't do that. So, our position would be, absent any proof that we met our standard of care, that we took reasonable mitigation efforts, and we haven't seen anything to show otherwise at this point.
But
Probably out
couldn't,
of time, is that why you hit that button?
You have about a minute left.
Okay, all right.
couldn't a reasonable juror conclude that this ought not have happened had the proper standard been followed? Without an expert?
I don't think so, Your Honor. I mean, just because, again, we could have had the absolute ultimate standard of care, and we could have had a rain event that any reasonable architect or engineer would not have anticipated.
Well, is that what
So you have to
happened?
know that.
I mean, was this a really significant 100-year rain event?
Well, if you look at that time, we've had significant rain events that have happened since people indicate the climate change and all that, and just
No, I'm talking about this specific.
Your Honor, again, if we had an expert, and an expert would have probably testified, this was the precipitation that occurred that day, this is how much rain came down, these are the mitigation efforts, these mitigation efforts are intended to be able to mitigate this much rain over a period of time coming down at a certain rate. We don't have any of that.
But absent any evidence of some significant rain event, a reasonable person could find, under normal circumstances, under normal rain events, this kind of flooding ought not have happened in a construction project of this sort.
I don't think it's a layperson. I wouldn't concede that, Your Honor. I think it, as the trial court properly determined, that you need an expert to determine what the standard of care is when you're doing a construction project. There were mitigation efforts in place. It wasn't if nothing happened. You saw the fences in the pictures, and they've identified that. So the question is what the district architects did on their behalf, whether that met that standard of care. And I would think that a jury or a layperson is not qualified to make that state determination.
And counsel, you're out of time.
Thank you.
All right, Mr. Kelly. And as counsel is coming forward, if you could please identify the party that you represent for us. Thank you.
Absolutely. Your Honor, my name is Phil Kelly. I'm here on behalf of Juergens Construction. Good morning, and may it please the court. The trial court properly granted summary judgment for three separate and independent reasons. First, the statute of limitations bars this action as it was not brought within the 4-year limitations period. Second, appellants have not provided an expert opinion which is necessary to establish the prima facie elements of their negligence claim. And third, the release agreement between appellants and Juergens Construction bars their claim. The first two issues have been discussed, so I'd like to spend my limited time discussing the release agreement, which is somewhat unique to Juergens Construction, unless, of course, the court has questions on any of the other issues. The settlement release agreement between appellants and Juergens Construction was executed on February 21, 2018. The agreement is broad and releases, quote, all claims and damages resulting from or related to the property damage resulting from the construction being performed by Charles F. Juergens Construction Incorporated at Reading High School, end quote. Appellants argue that this release does not bar future damages. However, a plain reading of the release agreement suggests otherwise. There are numerous provisions that specifically address future damages. For example, the second paragraph of the release mentions future damages twice. In the first sentence of the second paragraph, it refers to property damage, quote, existing and arising in the future, end quote. In the second sentence of the second paragraph, it states the release is a full and final settlement of all claims and damages that appellants, quote, may have in the future, end quote. This unambiguously and clearly states that the agreement is for future damages. Also telling is that the release agreement has language stating that it releases property damage, quote, occurring and, quote, resulting from the construction at the Reading High School. The present participle use of the language occurring and resulting indicates that the agreement intends to release damage that is not only present but also continuing in nature. And most notably, there's no limiting language in the release agreement which would suggest that it was only intended to apply to damage that has already occurred. As discussed, the language, in fact, indicates just the opposite. With that being said, I would like to address one of the issues that Judge Moore raised. It sounds like you were making the argument, I guess you could say, that but for the negligent construction, this would have resulted in the damage. That, to me, is a res ipsa argument or a strict liability argument, which has never been pled. That would be the first time the issue was raised. And
Well, this is summary judgment, counsel, so the court below determined that there was no reasonable person could conclude otherwise. And my question was with respect to the fact that in construction projects like this, it's not expected that water would go running down a hill where it had not run before and cause the kind of damage that plaintiffs are alleging. And my question was simply, couldn't a reasonable fact finder look at that situation and say something happened here that was wrong, incorrectly done, and it should be heard?
Your Honor, I think that would be a res ipsa loquitur argument, that because there was damage or water running down, there had to have been negligence at this construction site. And I simply don't think a res ipsa argument can work here for two reasons. I mean, there's no control, none of the parties have control over the instrumentality that's causing this damage. I mean, this is rainwater that we're dealing with.
Well, I'm going to push back on that a little bit. Yeah, no one can control the rain, but where the water flows, that can be controlled.
Yes, absolutely, Your Honor, and I would argue that the burden is on the appellants to establish that the rain was in fact, the flow of the rain was in fact caused by a deficient swale or berm or something of that nature.
Well, the rain fell before this project, right?
I'm sorry, can you re-ask?
Rain fell before this project started, correct?
Yeah, absolutely, Your Honor.
And there was no flooding in the plaintiff's house, right?
I think that's an accurate statement, yes, sir.
And the construction project ensued, trees were removed, ground was moved, and flooding ensued. Is that right?
Yes, Your Honor.
So couldn't a reasonable person conclude that as a result of the construction project, the rain that had not previously caused problems is now causing problems?
Not necessarily, Your Honor, because there, as co-appellee mentioned, there could be a perfectly well-constructed swale or berm, and a rain event just so happens to overcome that.
But there's no evidence that we had any kind of substantial rain event like that. This is just, at least my understanding of the record, this is just normal rain. There was no hurricane or other event.
Yes, Your Honor. I see my time is up here. I will I will go ahead and sit down, and co-appellee Shook Touchdown will be making its argument. Thank you.
Thank you.
Thank you. Mr. Anderson.
Thank you. My name is Skilled Anderson. I'm here on behalf of Shook Construction. I'll do a little bit of cleanup. Judge Kinsley, you asked whether the plaintiff appellant briefed the continuing trespass in the trial court. The answer is no. That's at memo contra, pages 11 through 14. We haven't talked much about the statute of limitations. It's pretty obvious that the first instance was in June 2017. Your guys are focusing on experts. And, you know, contrary to what my co-counsel says, I think the 100-year rain is a red herring. You can't tell whether there was anything wrong because the plaintiff didn't meet his burden. So you ask good questions on both sides. There's no strict liability. There's no res ipsa. This is the plaintiff's burden.
Well, counsel, again,
Yeah, sure.
you say there's no res ipsa.
Yeah.
But I'm still struggling with the fact that this didn't happen before. The construction ensued. So
Okay.
couldn't a reasonable person say that something wrong happened as a result of the construction, because this normally shouldn't happen?
No, no, it does happen. It happens every time, and that's why you have erosion control measures. That's not in the record, and I understand you feel like it shouldn't happen, but that's not in the record. It happens every time, which is why they deal with it every time. And
Well,
you
I'm
can't
sorry, you
tell-
say they deal with it, and
Yeah.
they deal with it, and it prevents the flooding, right?
No, no. That's why the EPA comes in and checks for the erosion control. It happens, so.
So I'm sorry,
So
counsel,
there was damage. I'm sorry, go ahead.
with erosion control, you're saying there's still this type of flooding that happens all the time?
Yeah, sure. So this type of flood, what happened for this fella is he got it pretty bad. And I'm sorry about that, and I feel bad for him, really. But you can't tell why. It's not just because it happened, somebody did something wrong. The folks haven't met, the plaintiff appellants haven't met their burden.
What's the purpose of the erosion control?
Actually prevent mostly silt. It's silt.
So what
Actually, it's
prevents,
not water.
what prevents the water from going down the hill? What steps should have been taken?
We don't know because there's no expert. That's the point. That's the whole point. So what you're saying is, it happened, so somebody did something wrong. No, that's not. We would submit that just because a bad thing happened doesn't mean that plaintiffs met their burden.
Well, did they at least create a question of fact?
No, they didn't meet they didn't, not at all. If you don't have an expert saying that this was pleaded as a construction and design defect. If you don't have an expert telling you it was a design defect, no, they didn't come close to meeting their burden. All they showed was that there was damage.
And counsel, you're out of
Thank you.
time. Thank you. All right, and Mr. Moore.
Your Honors, Bruce Moore on behalf of Voorhees, Sloan, Walsh, and Crossland Architects. May it please the court, I wanted to first touch on the fact that our argument related to the experts is a tad unique, as we did submit affidavits from our own experts indicating that, one, Voorhees did meet its standard of care and design for this facility. Two, that the standard of care and the nature of an architectural design is highly specialized and not something typically within a layperson's knowledge. Those are facts that were before the court that were not contradicted by any testimony, any evidence, or any affidavits submitted by appellant. So in that regard, a design expert was necessary to establish the standard of care, but also the only evidence before the court was that that standard of care was met. Moving on to discuss a couple of the points that my co-counsels brought up. First, I'd like to point out that Robert Rawlings was not actually an expert in this case. I know that was brought up by appellant. Robert Rawlings was actually a civil engineer that was hired to assess the situation, but was not an actual expert or qualified in this matter. Secondly, there have been several cases in which Ohio courts have found that an architect, to determine a standard of care, that it was outside the expertise of a layperson. Lawrence v. Jeffrey out of the 11th District, Site 205-4043. There have been Ohio courts that have required expert testimony to establish negligence where water damage was allegedly caused by construction defects. That'd be Claris LTD v. Hotel Dev Services, 10th District, 2018, Ohio 2602. Moving to the continuing trespass argument, the 5th District actually...
Before you go
Yes.
there, was the removal of the trees, was that part of the design plan?
To be fair, I'm not sure, Your Honor. There was no expert to analyze what the actual design plan was relative to the project versus what construction. And that goes to Judge Moore's question. Could a layperson determine that there was something wrong? Your Honor, I believe yes. They could say that before the situation, rain came down, there was no rain getting into the building. But what a layperson can't determine is, was it a design? Was it a construction issue? Was it the fact that the silt fences were inundated by a 100-year rain event? All of those things would require expert testimony, a burden that the appellant had and the appellant failed to meet. So that way a jury could determine what happened. Because there's a chance that it's not a negligent act. As my co-counsel has mentioned, it could have simply been that an actual, that a mitigation measure that met the standard of care was overly inundated by a 100-year rain event. We never got to that point because there was never an expert to rebut. We never knew what their position was. Moving on to the continuing trespass.
Counsel, you're actually out of time. Thank you.
Thank you, Your Honor. I would like to begin by, the main issue here is the statute of limitations. And what the court's duty is here is, we've recited a case, Hammer versus Grand Trunk Railroad. It's from 2024. I've cited that in my case. And what this court's duty to do then is first to determine which statute of limitations would apply and if one started. And second, determine if there's an issue of fact about when that statute would specifically apply. Following that, we have, maybe the flooding began in June of 2017, or maybe it began in October. But in any case, it continued long for that. The evidence we have showing, for example, the site observation where the contractors presented the evidence to the neighborhood people, including my clients, that stated March 5th, 2020, or 2018. That would be less than 4 years from the time that that this case was filed and within the statute of limitations. So the question here, the question there is there's an issue of fact, and that would prevent the dismissal based on the...
What is that issue of fact? Because I don't hear the defendants to be disputing anything that the Browns are saying. I think everyone is on the same page that they observed some water in June of 2017. They took some pictures, they had some meetings, and then the water was much worse. The infiltration was much worse in October of 2017. I don't think anyone disputes that. So what is the actual fact that you think has not been resolved?
Okay, see, the situation you just said there, following the Sexton case, it would be that the statute of limitations did not expire in June of 2000, or did not begin running in June of 2017. It began running much later, and there is no evidence. In fact, none of the defendants have put forward any evidence of when that flooding stopped. I only pointed out the March 5th date for the site observation that showed that it continued well within the statute of limitations, and that the statute of limitations, which is an affirmative defense, and it's their burden of showing, they have completely failed to do that. So that evidence, I would say, completely shows that the statute was still timely.
So I want to make sure I understand your position. Your position is that they carried the burden to disprove the continuous violation exception to the statute of limitations, even if it was not raised in your response?
Yes. Yes, it's their duty. It's an affirmative defense that they're asserting. If you look at the motion for summary judgment, it's determined the burden of proof is with the moving party.
Do you
They're
have
the
any
moving party.
case law to support your argument that the defendants must disprove the exception, even if it's not raised?
Yes, because that's the standard. You'll find that's in the Sexton case. That's in the state a criminal case that was cited. I think State versus Swartz.
Well, in the Sexton case, it was litigated. It was raised by both sides and litigated.
Right, but in
The
that
trial
case,
court didn't have an opportunity to review the continuous trespass violation in this case. And now you're asking us to review it. Why
Yeah, but
should
what-
we do
what-
that?
Yeah, but what happened was the Court of Appeals, remember, the appellate court is acting de novo. They determined in that case that
But we don't review issues that are waived when they're not raised below, so why should we do that here?
When the statute of limitations began and when it ended was in fact raised in the case. That evidence was before the court, Your Honor. You'll see citations in the record to the October 5th, the site observation and the determinations that were made there. And that shows that there was an extended statute of limitations. We allege that in the complaint too. And they failed to counter provide any evidence that the flooding did not continue beyond the time as is set forth in the complaint and set forth in our motion for summary judgment. Also, I would like to add, there's been a lot of talk about the expert witness here. If you look at the evidence in the record, there was an expert presented in this case at the site observation, and it was an expert retained by the architect firm and by the other defendants, and he wasn't so it's not an issue of architectural design, it's an issue of landscaping and civil engineering.
Was this person, I think it was Mr. Rollins, is that correct?
Please?
Mr. Rollins, is that who you're referring to?
No, his name is Rob Roberts.
Rob Roberts. Okay, was Mr. Roberts identified as an expert witness?
No, he was retained. You'll see when it says in that he's specially retained to deal with the landscaping by the architects, and he talks about that, and he leads this site observation group through there. He's acting as a witness. I don't think they called him a title, but he's acting as a witness. And he specifically sets forth what's additional steps they're going to take to try and stop the flooding, which is putting these large bales of hay up front and grading the upper part of the land.
Well, did he say anything about what caused the flooding?
No, he didn't address that. He only was talking about I think it was assumed when he talked that the construction was causing it, and he would have to take steps to prevent the construction, to prevent the flow caused by the construction, and he was going to do that in a particular way by holding on to by channeling by putting up the plastic fences that would channel the flood of the water and have it flow down into this natural thing at the bottom of the creek that did not happen at the time. So we would say that in any expert testimony, if you were going to, that's an issue about, it's not an issue about the statute of limitation, it's an issue about the substance of the case. But if we were going to do that, a reasonable person would be able to see that and understand what steps they were trying to take. It's not anything complicated, and it doesn't require, it would be within the knowledge of of a reasonable person or an average juror, and we think that is not a bar to allowing this case to continue.
So is your argument that this Roberts fella testified as to what should have been done to prevent the flooding in the first place, or he testified as what could be done to stop the further damage from the flood?
Okay, what he testified to, and it's not really testimony, it's in a memo that was submitted to all the residents after this site observation and the discussion and
So he's not even really a witness in the case? His report came in through the deposition of your client, is that right?
Well, yeah, it was evidence that was provided. It was part of the discovery disclosed by my client, and we authorized it in her affidavit and added that into evidence at that point, and we relied on that. Judge Moore, what he actually said is in there is he provides what they're going to do to prevent further flooding. So he didn't explain the cause, but he explained what steps would be needed in order to prevent the flooding from continuing. And that's what, and it's set forth in that statement that was submitted, in which my client has authenticated through her and submitted through her affidavit.
Thank you.
Thank you very much, Your Honor.
Thank you all for your advocacy this morning. We will take the matter under submission and issue a timely decision. Enjoy the rest of your day. All right, the second case on our docket this morning is C-25-0001, Tabasha versus Abdul Rahim. You may come forward. Would you like to reserve time for rebuttal?
Yes, Your Honor.
How many minutes?
3 minutes.
All right. You may begin when you're ready.
Morning, Your Honors. A little change of pace from the last case here. Your Honor, in the United States, under Ohio law, the rule on marriage is monogamy, that a person cannot be married to more than one person at a time. Bigamy is prohibited, and a bigamous marriage is void ab initio. That's the case in Ohio. That's the case all over the country. The basic facts of this case, Your Honors, appellant married his wife, Dalia Hassan, in 2003.
Is that disputed in this case, or is that an accepted fact?
Which one, Your Honor?
That your client is married to Dahlia?
That's established.
All right, thank you.
In approximately 2018, 2019, appellant and appellee began a relationship that ultimately resulted in the birth of a child. Appellee proceeded then to file a case of marriage and support in Egypt. Neither at the time of appellee filing her case in Egypt nor since was either party domiciled in Egypt. Both parties have consistently lived in Ohio since prior to the case filing in Egypt. In the proceedings in Egypt,
Counsel, why isn't this a matter for the Domestic Relations Court?
I'm sorry?
Why isn't this a matter for the Domestic Relations Court versus the General Division?
Your Honor, the nature of how this marriage was established raises that question. If you look at the annulment statute, maybe that's what you're getting at, that this perhaps could have been an annulment matter. This wasn't a marriage that the appellant entered into. This was something that was imposed upon him. There was no solemnization of this quote-unquote marriage. And if you look at the annulment statute, the grounds that are given for annulment, they all involve some sort of solemnizing of the marriage, which wasn't the case here. So the declaratory judgment statute, which states that the power of declaratory judgment actions rests with all courts of record, gives jurisdiction to the General Division.
Okay, thank you.
Can you repeat that last sentence, the last clause of your sentence? I couldn't hear what you were saying. You said that the jurisdiction to issue a declaratory judgment rests with, and then I couldn't hear what you said.
All courts of record.
Okay, so the Domestic Relations Court could make a declaratory judgment regarding whether a marriage is valid, whether the Egyptian court established a legal marriage under the laws of Ohio.
So, Judge Bach, that's a great question. The general declaratory judgment statute states all courts of record. However, in the probate division, that authority is specifically given to the probate court, but that authority isn't specifically in the domestic relations statute. So the fact that the domestic relations court would generally have jurisdiction over issues of marriage and divorce is true. But in this particular case, was it even a marriage? Because a court in another jurisdiction where neither party was domiciled, which is a requirement, a court finds based on the fact that a child was born from a relationship that they're married. That doesn't fall under really the definition of marriage. There was no consent to it. This was something that was imposed on my client, on the appellant, by a court. So before we get to the issue of domestic relations, the action was to have a court declare, based on the fact that you cannot have more than one, you can't be married to more than one person at a time, what is the status of these parties where a decision has been given in a foreign jurisdiction where neither party is domiciled, where there was no solemnization, the alleged marriage didn't even take place there.
Would any court in Hamilton County have the power to tell the Egyptian court that it was wrong and that it should not have declared, or it should not have issued the marriage certificate?
Well, I think the Hamilton County Court would be issuing a declaratory judgment as to the status of these individuals in relation to each other. So a Hamilton
In
County
essence,
court-
aren't you asking that the Egyptian marriage not be recognized in Ohio?
Yes. So we can state that in different ways, Your Honor. Is it void ab initio? Are the parties not married? Right? But essentially, yes.
And
that wasn't a valid marriage.
Would annulment accomplish the same objective?
Ultimately, it could. However, it implies that there was a marriage. In order to annul a marriage, you have to find that there was a marriage to begin with.
Well, there is a marriage, right? I mean, there's no getting around the fact that an Egyptian court has determined these two parties to be married.
Under Egyptian laws, perhaps?
Right.
Under religious laws?
Right, there's no getting around that.
That there is a decision from an Egyptian court, correct. However, the law is also clear that if that marriage took place in a jurisdiction, well, let me apply it the other way. If a party sought a divorce in another jurisdiction and neither party was domiciled there, the case law is pretty clear that divorce is not valid. So how
Well,
would a marriage-
is it clear to us in this court, in this county, or is it clear to the other jurisdiction? Do you understand what I'm saying?
The other jurisdictions?
You just gave the example about divorce.
Yes.
Okay, so yes, here, the rules say that you cannot get a divorce in this venue, in this jurisdiction, absent the minimum residence time.
Right.
So, but if the jurisdiction in which the divorce occurred does not have that rule, is the divorce still valid?
Well, in that jurisdiction?
Mm-hmm.
I don't know if it would be valid in that jurisdiction, but the domicile in which the parties reside, that court would have to make a determination, which has happened in multiple cases, even in the state of Ohio.
Okay, let me back up
Party
for a
went
second.
to-
Let's say that a couple got married here in Ohio. And then they decided they wanted a quick divorce. I don't know what the laws are anymore in Las Vegas, but let's say they went to Las Vegas to get a divorce and there were no domicile requirements there. Would the divorce be recognized here?
I think a party that disagreed with it could, in this county, ask to declare that it wasn't.
Okay.
I'm sorry, Judge Kinsey, you were...
I just, I want to explore the impact of this Egyptian court decision, right? Because if the remedy you're seeking is to change the Egyptian court decision, isn't your remedy in Egypt?
It's not really to change the decision, Your Honor, because the issue we're talking about, it's not just someone saying, oh, you know, I want to void that marriage for whatever reason, right? It's someone saying, I never married this person. We didn't go through any of the formalities. We don't live in Egypt. Somebody goes to a foreign country. It could have been France, right? It could have been Russia. Someone who's, has a child out of wedlock goes to a foreign country and says, I want a decision saying that I'm married and I'm entitled to support. That's really what's happened here. But the person who
But
didn't
an
enter-
American court has no jurisdiction to alter or change the determination of a foreign court. We cannot do that.
But-
In the same way that a foreign court cannot alter or change the decisions of our court. What we can do, in theory, and we can talk about and assess what this looks like, but in theory, what is available is a determination as to what the impact is of a foreign court's decision. But our courts cannot undo or reach into the decision of a foreign court and change it. The exclusive remedy is to appeal and avail yourself of the process in a foreign jurisdiction.
So, Your Honor, that's where the principles of comity come in. Because an Ohio court doesn't have to recognize a decision or a judgment of a foreign court.
So what is
It
the
conflicts with
remedy?
public policy.
What is the remedy that your client is seeking?
He's seeking a declaration that he and the appellee are not married.
Under the law of which jurisdiction?
Ohio.
All right. Thank you.
Okay.
Thank you for clarifying that.
Yes, so to be clear, we're not saying that this court has the authority to vacate an order of another court, but this court has the authority to recognize or not recognize, or give full faith and credit or not give full faith and credit to a decision of another court, but the court still needs to consider what is the impact, based on our public policy. And our public policy in this country has always been that it's one spouse at a time, basically. And in this case, once again, this wasn't a marriage that the appellant entered into. It's been forced on him.
Can you explain for me why a declaratory judgment from the general division would, in essence, if you get all the relief you want, that court would be saying, Ohio courts under Ohio law do not recognize or give full faith and credit to the Egyptian decision. Why is that superior to annulling the Egyptian decision in domestic relations court?
Your Honor, again, as I see it, the fact that the court imposed a marriage upon him without him taking any affirmative steps or consenting to a marriage, it doesn't meet the definition of a marriage in Ohio.
Does the court need to make those factual findings to give your client the relief he seeks?
Which?
Make the finding of the forgery and the process problems that you've alleged?
No. Just the fact that that a marriage has been imposed upon my client and he is already married to someone and still is, the subsequent marriage can't be valid. That's the bottom line. I don't know where we are in time.
You can wrap it up.
Okay. Your Honor, I think most of the other issues we've briefed, but just briefly on the procedural grounds. Your Honor, we filed a complaint. It had pretty extensive factual allegations, none of which have been disputed. When the motion to dismiss was filed, and the issue was raised about whether or not there was a justiciable controversy, new facts arose after the complaint was filed, in which the appellee filed a new case in Egypt asking for spousal support and for reimbursement of child care expenses, which then created a real financial impact for the appellant, which is one of the elements for a justiciable controversy. So the appellant filed a motion for leave to amend the complaint to include those facts, but the court, in ultimately dismissing the action, denied that motion for leave to amend. But the case law and Civil Rule 15 state pretty clearly that it's a severe remedy to dismiss a case on grounds like that. And if the facts were deficient in some way, and we're a notice pleading state, but if the facts were deficient in some way and new facts had arisen, then the court should have freely granted leave to amend the complaint to include those facts and then rule on the motion. But the court went ahead and just dismissed it, so that was unreasonable on from the trial court.
And counsel, you're out of time.
Thank you, Your Honor.
Thank you.
Using my phone as a timer is not going to work on the podium. May it please the court-
There are lights in front of you.
Try to pay attention.
Thank you.
Good morning, judges. My name is Blake Summers. I represent the appellee, Lamia Abdul-Rahim. We're requesting that the trial court be affirmed and that the appeal be denied. So we should probably talk about jurisdiction since we did our supplemental briefs last week. So I think there are probably, from the cases that we reviewed and the cases that we supplemented the court with, I think there's probably two principal reasons from those cases that suggest subject matter jurisdiction may have been lacking below and still here. One is a direction the court was kind of headed last time, which is that this could have been brought in a special statutory proceeding for an annulment. And two is the relief that plaintiff ultimately seeks is beyond the jurisdiction of the common pleas court to grant. So for that first idea, there's a pair of cases, it's Jones and Staffolino, that suggests that a declaratory judgment really is not an appropriate substitute when there's a statutory remedy available. They said, if there's something that is committed to special statutory proceedings, it's not appropriate to issue a declaratory judgment, which is tantamount to holding that courts have no jurisdiction to hear the action in the first place. I think even from the outset, Jones and Staffolino kind of suggest that because the remedy of annulment is available, declaratory judgment is not appropriate.
Is an annulment an equal remedy here? I mean, it strikes me that annulment is prospective, so it's going forward from the date of the court's decision, assuming that one could be granted. And it's not, it wouldn't address the time period from the Egyptian court's decision until the annulment, but a declaratory judgment might.
So I think there's probably two answers to that, and almost, I'm going to take the kind of two questions that are in that almost in reverse. So the second question about the time period in between them, right? I think those are, at least currently, matters for the Egyptian courts to decide. The court is correct. There is a venue for a plaintiff to get relief that he seeks. That venue is just not the Hamilton County Court of Common Pleas. The second issue about whether the annulment is an appropriate statutory substitute is something that I was looking at last night. So I'm reading these cases again and I'm thinking, well, when I see special statutory proceedings and I see those words in that order, I think that's supposed to mean something to me, and it does. And so I started trying to figure out whether an annulment itself is a special statutory proceeding. In doing that, I kind of backed into some additional authority that was not in our supplement, I'm sorry, but it is Nixon versus Day. It comes to us from the 5th District in 2019. The case site is 2019, Ohio, 3335. If the court wants, I can file a one-page supplement after argument. But Nixon has some at least kind of helpfully analogous facts. So in Nixon, an elderly gentleman tried to get a marriage license in Tuscarawas County. Can't say it. And it was kind of held off by the clerk because of some competency concerns. The groom and the bride go over to Indiana. They get a marriage license issued there, and they get married. A few days later, back in Tuscarawas County, the clerk says, I'm not going to issue a marriage license. In fact, the probate court grants an emergency guardianship over the groom. That gets extended, and then the guardian files a declaratory action in probate court seeking an annulment of the Indiana marriage. So the court hears all this. They do issue the declaratory judgment. They grant the annulment of the marriage through the declaratory judgment action in the probate court, and at that point, the wife appeals. By that time, unfortunately, the groom had died. I don't know if that's relevant. I don't think so. But so during that appeal, the court looked at two things that are helpful. One is they kind of contrasted the annulment statute and the declaratory judgment statute and framed the question in a way that I think is helpful to us, which is, does a probate court have jurisdiction to grant an annulment within a guardianship action under the probate court's statutory power to grant declaratory judgment or its plenary powers? So I think it's at least kind of addressing from a distance perhaps what we're talking about here. The court first looked at some history of annulment statutes and of marriage statutes and did conclude that an annulment is a special statutory proceeding because it didn't exist at Ohio common law. And so that I think that does help us a little bit with Jones and with Staffolino to suggest that if it is a special statutory proceeding, it's available and the complaint should have been brought as an annulment action. But Day also goes a little bit further. So ultimately the court in Day found that even though or even if there was concurrent jurisdiction between common pleas and domestic relations, the action still should have been brought as an annulment in the statutory DR proceedings rather than a declaratory judgment action. So I think the three of those cases put together, I think Jones and Staffolino and Day, really suggest that because of the available, and this is a long way to answer your question from like 3 minutes ago, but I think they do suggest that because of the available statutory remedy via an annulment, that's what should have been pursued, and that because it wasn't, the court below probably did lack subject matter jurisdiction for that reason. The second point, I think, comes from Ford versus Ruhlman, which says that while a declaratory judgment statute provides an additional remedy which may be granted by a court, They do not extend jurisdiction as to the subject matter upon which a court may act. And I think that gets to at least some of what the court was talking about before, is that the Common Pleas Court in Hamilton County, Ohio, despite its vast grant of jurisdiction, does have no jurisdiction whatsoever to set aside the judgment of an Egyptian court of appeals. And so because the court below lacks the ultimate jurisdiction to grant the relief that plaintiff seeks, I think conceivably Ford versus Ruhlman also suggests that the court below lacks the subject matter jurisdiction to issue a declaratory judgment on those grounds.
Well, isn't the request somewhat broader than that? I mean, it seems like, looking at the complaint, that some of the requests for relief are in the nature of, vacating or changing or altering some aspects of the Egyptian court's decision. But some of the relief requested is in the nature of whether Ohio is going to recognize the Egyptian court's decision.
So there are 5 claims for relief below. When I got the court's order, and maybe I misinterpreted it, I thought it was pretty narrow. And when I read it, I thought it was addressed to basically the first half of the final claim for relief. And I think the authorities that we've talked about between Ford, Day, Staffolino, Ruhlman, Jones, I think they suggest that subject matter jurisdiction probably did not exist over that portion. But I also think when we look at those authorities, I think they apply with equal force to the other claims for relief that were raised. We've gotten a bit of a different claim for relief today from appellant than I think was necessarily contained in the complaint. But I think that the other portions of the complaint itself are still fallible on the same ground. So if you look at claims A and B, I don't know that the court has any general jurisdiction to do what the plaintiff is asking in those, which is to declare a signature a forgery. I don't think the Common Pleas Court has the general jurisdiction to just say, well, I don't think that's a real signature. And so I think that runs into
Well,
problems.
and wasn't that factual question already determined by the Egyptian court?
Yeah, so there's a little bit of a disconnect with plaintiff's presentation of whether it was a forged signature. If you really get into the record, I can get a pinpoint site if it helps, but the record's not super long other than the pleadings. But the Egyptian court actually found that the documents did not contain plaintiff's signature, which is a little bit different than a forgery. But in any event, because the court doesn't have the jurisdiction to even do that, I think that suffers from problems under Ford versus Ruhlman. I think claims C and D also suffer from the same statutory remedy problems that we get from Staffolino, Jones, and Day. And then once we get to E, I think the latter half of that goes back to Ford, because to the extent that it seeks to void a marriage declared by a court in Egypt, I don't think the court has any jurisdiction to do that. The plaintiff has kind of suggested that because the court has general jurisdiction over a common pleas or over a declaratory judgment action, that it creates jurisdiction in this case, but I don't think that's quite enough, right? So I actually thought about the exact same thing, Judge Bach, you did with the divorce, right? 310503 says the Court of Domestic Relations has subject matter jurisdiction as long as the plaintiff in the action has been a resident in the state of Ohio for at least 6 months immediately preceding the divorce. But that general receptive grant of jurisdiction doesn't necessarily mean that you have jurisdiction in a particular case, right? There is tons of case law talking about whether the plaintiff properly established jurisdiction under 310503, including from this court. It's Griffin versus Griffin from a couple years ago talks a lot about jurisdiction, right? So I don't think that just saying well, there's a declaratory judgment statute and it has jurisdiction for the courts of common pleas, so that gives us jurisdiction here. I don't think that's quite enough. And I think based on what's been supplemented to the court, I don't think there was likely subject matter jurisdiction below, and I don't know that there's subject matter jurisdiction over the claims at this point, whether it's because of the available statutory remedies or whether it's because the relief that the plaintiff seeks is outside the jurisdiction of the court to grant. So I think I've probably used a lot of my time on jurisdiction. With permission of the court, I will just briefly discuss 2 things. One is res judicata. The second is the idea of comity. The trial court below properly found that even if there was jurisdiction, even if we get past that the plaintiff's claims are still barred by the doctrine of res judicata.
Okay, I'm going to drill down a little bit on that. for A and B, those appear to be squarely addressed by the Egyptian ruling. But for C, D, and let's just look at C and D for now. Was that decided by the Egyptian court?
I don't think so, because I don't think that would have been in front of the court, because they were not looking to determine whether oh, I see what you're saying, for purposes of res judicata.
Yes.
Okay, I got it, I'm sorry, I thought you were going back to Savalino and such. So no, you're right, I don't think that that particular issue was probably in front of the Egyptian court, but the claim or the fact or the issue that is at issue in front of the Egyptian court is the same one that was in front of the Court of Common Pleas for purposes of res judicata. So regardless of whether it's A, B, C, D, or E, I think those claims were properly found by the court below to be barred by the doctrine of res judicata. It's the same claim, it's the same issue, it's the same facts. Was there a marriage, right? It's the same parties, and there's at least been no suggestion that the court in Egypt lacked jurisdiction to make that determination. It has to be a court of competent jurisdiction, but that really hasn't been otherwise. To your point, those questions, true, were not in front of the Egyptian court, but I think in terms of the preclusionary aspect of it, it was sufficiently in front of the Egyptian court that it constitutes prior final judgment between the two parties, and that the court below was right to find that this was really just an attempt by the plaintiff to relitigate what he lost twice in Egypt. He was represented by counsel in the court of first instance, whatever they call it. He was represented in the court of second instance. I don't know what they call it there either, but he was represented throughout those proceedings. It was just unsuccessful. So it doesn't make any sense to have him then come to Ohio and file a declaratory judgment action saying like, hey, I think this decision was wrong, right? I'm not trying to do a parade of horribles, but if any judgment from a foreign jurisdiction was later subject to the declaratory judgment authority of Ohio courts, then there would be really no limit to how that jurisdiction ends, because anybody that's dissatisfied in a foreign jurisdiction could come here and say like,
But you see his quandary though, right? Because, I mean, it appears to be undisputed that he is married in the United States to someone else. And so he appears under two different sets of laws to have two different wives. And that places him in a potential legal quandary, as well as, I'm assuming, a moral and ethical and practical one. And so he wants relief. He wants a court in Ohio to release him from lawful compliance in Ohio with the burdens of the Egyptian marriage. Where does he go for that kind of relief?
So I was in complete agreement until you got to the words relief in Ohio, because I don't think Ohio is the appropriate jurisdiction to seek that relief. If the plaintiff wants relief, he had it available to him in Egypt, and he was just unsuccessful. Like any other litigant who is unsuccessful, he may be unhappy with that outcome, but that doesn't mean that he gets to collaterally attack the judgment that he didn't like in a common pleas court on a different continent. Right? To the extent that he's indicated there are potential obligations that may be imposed on him, this is way down the line, but all of those all fail on the idea of speedy relief. In order to get a declaratory judgment, he has to show that there is something he is at risk of. This court has said, like, it can't just be hypothetical, it can't be remote, it can't be distant. Plaintiffs come nowhere near to even approaching a point where he's met that burden.
But wouldn't he be a bigamist if that Egyptian court decision were to stand? So seems like a very real
I
injury.
think there's a difference between the court's standard for speedy relief and real. And I'm not trying to cut a hair too closely, but the idea of a hypothetical future criminal prosecution, I think is insufficient, my gosh, to get to the level of speedy relief.
No, I mean, criminal prosecution aside, just in terms of the existence of these two alleged marriages, he is a bigamist.
Perhaps. I think the idea of where we draw the line on speedy relief might perhaps be a question for a different day, because I think regardless of where we draw the line in terms of speedy relief for purposes of a declaratory judgment, plaintiff has suggested nothing that gives him any concrete harm or gives him any concrete exposure to any risk. This is way down the line after we get past jurisdiction and the idea of res judicata that we even get to the idea of speedy relief. But to the extent that we do, I think those claims still fail. Does the-
Reputational risk is not immediate here?
Excuse me?
Reputational risk?
I think that plaintiff already encountered that reputational risk by fathering a child outside of the marriage, as he alleged in his complaint. And I don't know that plaintiff has pled reputational risk as a claim for relief that he seeks a declaratory judgment to remedy.
Thank you, counsel.
Your Honors, thank you so much. My time has expired. It was a pleasure to be with you this morning. We request that the trial court be affirmed. Thank you.
Your Honors, the decision of the trial court stated, defendant argues plaintiff is seeking to collaterally attack a valid judgment of another court of competent jurisdiction. Defendant argues no case or controversy exists because she's not seeking a declaration that she is married under the laws of Ohio or Michigan. Your Honor, there's a case, and I would ask the court for permission to supplement, to provide supplemental authority. I believe we both need to supplement. We have a few days to.
You'll need to follow our rules to do that.
Yes, Your Honor. Under the case of Litzinger Sign Company versus American Sign Company, jurisdiction is the key to full faith and credit. A judgment rendered by a court of another state is subject to collateral attack in Ohio if there was no subject matter or personal jurisdiction to render the judgment under the sister state's internal law, and under that law, judgment is void. So the fact that this, the Egyptian court issued this decision doesn't mean that it can't be collaterally attacked. No matter what stage, how far he went in the litigation, we still have to look at the impact of that.
So you are attempting to collaterally attack the Egyptian decision?
Well,
That's the remedy you're seeking?
well, that is within the scope of the court to do. But we may be talking about word choice. Is the marriage void? Are they not married? Is the judgment, of the Egyptian
Well,
court
I think the
void?
word choice really matters, especially in a declaratory judgment action when it all comes down to words in a court order, right? So what are the exact words that you want the trial court to say about this Egyptian marriage?
That the marriage between these two parties is void as a matter of public policy?
And it has the
void.
power to do that because?
Because the declaratory judgment statute and the court precedent across the country gives it that authority. But whether the court chooses to allow appellant to collaterally attack it, or to simply issue a declaratory judgment saying that that marriage is void or it's not going to be recognized, for him the result is the same.
All right, so perhaps you're seeking alternative remedies?
Yes.
Okay. Is there any current obligation that your client is facing under Ohio law as a result of the Egyptian court order?
Any obligation?
Yes.
That's a tough question to answer, Your Honor, because there's this litigation happening, there's a juvenile court case involving parenting issues and support and those kinds of things. So I can't.
Involving this child
Yes.
here in Ohio?
Yes. And I've cited it in the complaint that he has, he pays child support and child care expenses, but there's a current case pending in juvenile court right now.
And are his obligations in that case due to his status as the father of the child?
Yes.
Not due to his status as the husband in Egypt of the mother?
Yes, that's fair.
Okay.
But the same parties and the same child are involved in a case in Egypt. So addressing counsel's point about the consequences being far out, they're not far out. After the filing of the complaint and before the.
Which complaint? There's three different actions that you're talking
Right,
about here.
the complaint in The trial court.
Okay.
After the filing of that, the appellee filed an action for retroactive spousal support to 2019 and for child care and child support in Egypt, where she was already receiving child support and child care expenses here. So this wasn't something far out. This was
But
that was the
those
basis for-
obligations, if they occur, are pursuant to Egyptian law and the Egyptian court decision.
Correct. But
Right.
as far as what constitutes a judiciable controversy, financial impact is one of those things. So in seeking to file the amendment to the complaint, those were the facts that were going to be included to meet that factor.
So let me just make sure I have this clear. The action seeking spousal support, not child support, because I think that's a completely different issue. But the spousal support, that was filed where?
In Egypt,
So there's nothing in Ohio that was filed about spousal support?
no.
Thank you.
Counsel, you're out of time. You can wrap up briefly.
Okay. Your Honor, as far as the issue of jurisdiction, I know subject matter jurisdiction can be raised at any time. However, just to point out, it was not raised at the trial court level, and it wasn't raised on appeal until the court asked us to brief that issue. So that's it.
All right, thank you. Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision. Thank you and enjoy the rest of your day.
All rise. The Court of Appeals, First and District of Ohio is now adjourned.